Yep, there we go. Firstly, I'll introduce Adrian Bailey. Most of you will know Adrian. He is a principal of the firm and runs our Sydney office. He has a Master of Taxation and regularly presents for the Tax Institute, CPA, and many other groups. And I'm sure you'll get some great value from his paper today. Thank you.
Thanks, Paul. Welcome, everybody, to the presentation today. I hope you get something out of it. The last couple of sessions that we've had have been on some strategies in terms of asset protection. So we've looked at strategies in relation to your individually held assets, and we've also had a look at strategies in relation to company and trust held assets. Of course, one of the things that we need to really get a good handle on is what the law is in terms of insolvency and how that interacts with any sort of strategy that we might be considering putting into place. With that, we obviously need to be aware of what the provisions are and how they interact with what we do, what we can and what we can't do in terms of any sort of work that we might be doing if clients are looking like they are struggling or looking like there are some issues there. So the agenda today that we're going to run through is we're going to have a look at the relevant legislation. Now, this paper is heavy on legislation in that we really do focus on that. We also very briefly define really what asset protection is, have a look at the assets that would vest in the trustee in bankruptcy in an individual setting. And then in terms of that, the assets, what we also need to consider in relation to clawback provisions. Having a look at some of the Corporations Act stuff too. In particular, we're going to focus on holding company scenarios, so where we've got a two-tier structure, where we might have one company holding another company and some of the things that can arise there, as well as recapping on our solutions with our newfound knowledge from today, and having a look at what sort of things we need to be worried about in terms of the provisions and our solutions. So just recapping on those very briefly. The two main parts or two key legislation or pieces of legislation that we're going to focus on today, really the Bankruptcy Act and the Corporations Act. So with that, if we're dealing with the individual issues, so individually held assets and a person going bankrupt, then obviously we need to refer to the Bankruptcy Act. If we're dealing with a company or trust, it's the Corporations Act that is more relevant in those circumstances. That a lot of the provisions are similar in the acts, but there are differences. So we do really need to go back and have a look at the situation and the scenario and say that if we're looking at an individual issue, then we need to look at the Bankruptcy Act provisions, obviously. Of course, these aren't the only pieces of legislation that can impact on you from an asset protection perspective. And one of the other things to consider is family law. So we won't be covering it today. But issues in terms of Family Law Act, obviously that can expose assets that we may not think would necessarily be exposed. Other things like Family Provision Acts in terms of estate challenges, all of those obviously are in the world of asset protection when we're thinking about that. So there are also things that we might have to consider in the future. With that, jumping straight into some of the temporary changes that have come in due to COVID-19. So these were announced by the government in March. They are all slated or currently legislated to be 6-month only changes. Of course, that may change down the track if the situation continues, or they may just be decided that they're removed after 6 months. So we'll have to wait and see that. But for the next 6 months, in terms of the Corporations Act, some of the changes that we have currently. For statutory demands, so if there is a company who is the debtor, we can serve a statutory demand on them. And the end result of that is either they pay or they get wound up. That has changed due to COVID-19. So rather than originally we had 21 days to respond, it's now 6 months to respond. And also the threshold at which point we can make a stat demand has gone from $2,000 to $20,000. A fairly reasonable increase there, you would think. 2,000 is far too low. In terms of another change in relation to insolvent trading, there has been a safe harbour put in for the next 6 months, where the directors and holding companies are protected from insolvent trading claims, where that insolvent trading has occurred because of what you'd call the ordinary course of business. So say, for example, if we're in the hospitality industry and our pub is shut down, straight away you would think that's insolvent trading. But that would be captured by this safe harbour here because obviously with some of the restrictions that have been put in place, people can't help but to be put in that situation. So that's for the next 6 months. In terms of the Bankruptcy Act, so individually held assets and issues, again, there's been some changes there. We have 6 months to respond to a debtor's petition rather than 21 days. And the threshold at which time we can make a debtor's petition or lodge a debtor's petition, I should say, has been raised to $20,000 from $5,000. So some fairly reasonable common sense changes there to take into account, obviously, the changed world we currently reside in. Now, focusing on the Bankruptcy Act, and most of this paper will focus on that. So we'll be looking at really issues in relation to individuals and individuals going bankrupt. The first thing that we need to think about whenever we're thinking of asset protection is, well, what is actually the property that potentially could be at risk? And we find the definition of that within the Bankruptcy Act. So it's real or personal property of every description, whether in Australia or elsewhere. So one thing that strikes you straight away in terms of that definition, clearly having assets overseas does not preclude them from recovery proceedings under the Bankruptcy Act. However, of course, on a practical level, it does make it more difficult for the trustee in bankruptcy. But just because we've got a holiday home in Bali or something like that doesn't exclude it from our Bankruptcy Act issues. And you'll find that an issue with clients when they're completing their statement of affairs, and quite often they'll think that they don't need to include overseas assets, whereas they do. They have to make a full disclosure in relation to that. The assets themselves that the trustee in bankruptcy takes over is the property of the bankrupt. So in relation to that, again, we have a definition of property of the bankrupt, which is contained in the Bankruptcy Act. And that's the property divisible among the bankrupt's creditors and any rights and powers in relation to it. So we don't just have what you would consider to be normal property in relation to things like shares and cash. We also have things like rights. So we'll see some of the interactions with that during the presentation in terms of the way that has potentially exposed other assets, not technically held by the individual. So one of the classic examples of that would be an unpaid present entitlement or a beneficiary loan from a family trust. If we have a client who has been distributing to themselves but not cash flowing it and their entitlement has built up, that's property of the bankrupt. If they were to go bankrupt, then the trustee in bankruptcy would be able to exercise their right to call up their entitlement and expose the trust assets.
Adrian,
yes,
if I can jump in with a question in relation to the COVID changes.
Yep.
Question from Mark is, if they become insolvent in the grace period, will they be protected regardless if they incurred the expenses prior to COVID?
To be honest, I will have to come back and answer that properly. I can't give you an exact answer on that. So Mark will come back to you separately on that with that question. In terms of the legislation itself, like with many things of the announcements that we're getting at the moment, it was announced one day and legislated the next. So it's a little bit rubbery, the legislation, but we'll come back to you on that point. Any other questions, Paul?
No, that's it for now.
Okay. In terms of protection of assets, what we would want to do for clients, obviously, is protect them from anyone who would want to seek access to those assets. So that's what asset protection is. And considering our paper today, we're really wanting to have a look at the trustees in bankruptcy. So that's who we're looking to protect from. So in order to do that, we need to know what the pool of assets is. We need to know what expands the pool and what shrinks the pool as well. Because we need to know what sort of strategies we can implement in order if we're doing any sort of planning with clients. So in terms of what comprises the pool of assets in the first place, the pool will consist of items such as interest in real estate, plant and equipment, cash, debtors, personal belongings, and shares. And that's defined within the legislation as to what comprises the pool. The other thing that we need to be aware of is that assets which we may come into possession of or become entitled to at a time after we're bankrupt may become entitled to the trustee in bankruptcy may become entitled to them. So things like gifts to us if we're bankrupt, trustee in bankruptcy can get their hands on that. Refunds, tax refunds may be treated as income rather than property. Windfalls, so lotto or gambling wins, we don't want to be buying lotto tickets while we're bankrupt. Inheritances, and assets acquired with income earned during the bankruptcy. So all of those things can be exposed if we receive them after we're bankrupt. So one of the main things there, when you think about it, is obviously things like inheritances. We certainly don't want you don't want family members to die at any time usually, but we want to make sure that if that occurs and we're bankrupt, that those assets are not going to us, because if they do, they're going to go to the trustee in bankruptcy. On the slide here, maybe a little bit difficult to read for you, but the other thing that we need to know is really what is the timing of our bankruptcy. So it's not necessarily the date that the debtor's petition is served. And this table here goes through the different times of when we're deemed to have entered our bankruptcy. So that's important for two things. One, we need to know what things would be exposed during that time period, because it can go back 6 months or so. And two, we need to know what time that is, so then we can have a look at applying the clawback provisions, because all of those have timing requirements in them. So with that, we need to know what the actual date of what's called our relation back date, so our bankruptcy date is. So that's a handy slide. A handy table there. It's reproduced from the legislation if you want to know what that date is, and then you can do some work from there in relation to what's exposed and what's not exposed. It's important to remember that specifically within the Bankruptcy Act, the bankruptcy of a debtor doesn't affect the rights of a properly secured creditor. So if we have a mortgage or if we have a security interest over the assets, then those rights, subject to having a look at them to see how they came into effect, those rights are still secured. So we often talk about wanting to get into a position of a secured creditor. And that's why, really. Because even if we go bankrupt, the trustee in bankruptcy can't interfere with those rights. As I said, pending clawback provisions and those sorts of things, which we'll cover. So if we're a secured creditor, we know that we are going to realise what we can. The other thing, of course, that it does as well, it puts us into a position where we're in a better bargaining position with the trustee in bankruptcy. Because it may be the case that if an asset is fully mortgaged, they may take the position that it's not worth their time or money to try and enforce their rights as the trustee in bankruptcy in relation to it. So that's key, becoming a secured creditor, obviously. Other things in terms of shrinking the pool, there are exclusions contained within the Act in section 116. So some of those exclusions include property that is held by the bankrupt in trust for another person, some household property prescribed by regulations, certain other personal property of the bankrupt, property that is used to earn income, such as tools. So if we're a tradie and we've got our tools, trustee in bankruptcy, we can exclude those. Used primarily as a means of transport, so things like cars, if we need them for transport, or interest in a regulated superannuation fund. And we will examine a couple of these to see exactly how those exclusions work if we're looking to shrink the pool of what would be available to our trustee. In terms of super, super is one of those things that is safe unless it can be shown that we've been making what you'd consider to be unusual contributions. And those contributions are really, in terms of evidentiary reasons, are shown to be because we see there's an issue in terms of personal bankruptcy. Aside from that, super is fairly much excluded. And the reason for that is a policy reason, and it's stated by the judges in the case that's on the screen, Trevor Newton's Small Superannuation Fund, is that the legislative policy seems to be that a person should not lose what he or she has managed to provide for retirement. So policy reasons, the idea being that if we're providing for our own retirement via our super fund, then the government doesn't have to support us or support us as much as they would have otherwise. So that should be protected from these sorts of things. And that makes sense when you think about it. As I said, there are exclusions to that in that if we're putting in money into the super fund that we wouldn't normally do, and it can be shown that we did that in order to, in effect, defeat the trustee in bankruptcy. Other things such as household items, so these are contained in the regulations themselves and list out a variety of things. So your normal, what you'd consider to be your normal household items. So where you could have issues there is where you have things of great value in your house. So perhaps you're an art lover and you've got lots of valuable paintings in the house. So those could be at risk. But normally speaking, your normal sort of household items are excluded from the trustee in bankruptcy. Of course, we've got to take stock of these things to make sure that we know what we do and what we don't have if it looks like our client is going to be entering into personal bankruptcy. The other thing is assets that are held on trust. So with that, we need to have a look at whether things were actually held on trust or not, because we can have the scenario where the legal title to the property is in the name of the bankrupt. So obviously the trustee in bankruptcy is going to be asking questions about that. But if we can show that it's held on trust, then that is excluded, again, subject to clawback provisions if we've only just recently subjected it to the trust. So an example of that would be something like in New South Wales, where we can't record trusteeship on title unless it's a very particular circumstance. So the property itself may still be held in the name of the individual if they're the individual trustee. So we'll need to provide our evidence and show our evidence that it's actually held on trust for a particular trust in that circumstance. And that sort of evidence would be obviously declarations of trust if they exist, financial statements for the trust, all of those sorts of things. Now, trust-held assets generally. It's getting a bit old these days. 2006 was what's known as the Rich Star case, where there was a decision by Justice French in that case that in the situation with that, in that case, was that we had the individual who was in effect the trustee, they were a beneficiary, they were the principal, or the appointer of the trust, I should say. So in effect, they had control of that trust, total control. And the court in that decision effectively said, well, really, that's an alter ego of the person. And in terms of that, that's property that should vest in the trustee in bankruptcy. A couple of things to remember about Rich Star is that it was what is called an interlocutory application. So it's not actually a decision in that it's not the final decision of the court. But what it was an application for a freezing order on the trust assets until the substantive issues in relation to the Bankruptcy Act proceedings were finalised. So in that case, the court gave the freezing order until that was finalised, but it certainly hasn't really expanded a trustee in bankruptcy's ability to get hold of trust assets. And we've seen that in subsequent cases. And one of them more recently is a Queensland case in Fordyce and Rann from 2016, where the judge in that case said that Rich Star is really not support for a principle that, in terms of a de facto control of the trustee, alters the character of the interest of the beneficiary. So the courts since Rich Star haven't used it in terms of expanding a trustee in bankruptcy's ability to access trust-held assets. But it is something that we still need to consider in certain circumstances. So what about widening the pool of assets? We've seen how we can shrink them, or things that will automatically shrink them. Now we need to think about the things that will actually draw assets back into our pool. And that's, as I mentioned before, that's where things like the timing in terms of our relation back date, the date our bankruptcy is deemed, is important, because in terms of widening the pool, many of these things are widened by using clawback provisions. So with that, we have different types of transactions, and one of those are avoid transactions, avoidable transactions. So the Bankruptcy Act declares certain transactions as void against the trustee in bankruptcy. So it's as if they never happened, in essence. And what happens is that those assets come back into the pool of the trustee in bankruptcy. So the provisions themselves are sections 120 to 122, and we will work through those provisions so that we can see how they operate. There are also some other provisions in the Bankruptcy Act in relation to powers of the trustee to increase the pool of assets. And those are in relation to superannuation contributions, which I've discussed a little bit earlier. And they're also in relation to Part 4, Division 4A, which are entities controlled by the bankrupt. So those can expand to trust-held assets. However, as we'll see, aside from the comments on Rich Star earlier, we'll see that they're not really effective in most circumstances, but we'll come back to that. But first off, let's have a look at sections 120 through to 122. So section 120 is what called undervalued transaction, and on the screen is the provisions, and the next few slides will be the provisions themselves. So with that section, if we have a transfer for under market value, then that can be clawed back if it's within a certain time period. So the initial time period is 5 years before the commencement of the bankruptcy and ending on the date of the bankruptcy. And so we need to look back in the first instance 5 years from that date. So that's why I said that the date was important, to have a look at any gifts, in essence, or transfers where we haven't received full market value, because they could be subject to clawback. Now, in terms of that 5-year period, there is a shortening of that where we can show that we were solvent at the time of the gift. So it's either going to be 5 years or 4 years, but at the very least, it's going to be 4 years that we need to look back for any of these sorts of transactions. Now, there are some exemptions in relation to that. So things like payments of tax, maintenance agreements under the family law. And there's other things in terms of regulations. So even though we have made some of those sorts of payments, they're not going to be included, obviously. And as I said before, in terms of the time limits, 5 years, unless it can be shown that we were solvent at the time of the transfer. So then 4 years for that. Now, we also have a further time period that's between 2 to 3 years if the transfer will not be void if the transfer was not to a related entity of the bankrupt and you were solvent. So in most of the scenarios where we're doing asset protection work, we are going to be dealing with related entities. So it's really that 4-year period that we're going to have to focus on. And when discussing it with clients, that's often what we focus on is say, well, we can show you that you're solvent now. We need this gift to be in place for more than 4 years in order for it to be effective if we're making a gift of property. The other provision within the Bankruptcy Act that we focus on transfers to defeat creditors. So transfer of a property by a person who later becomes a bankrupt to another person is void if the property would have become part of the trustee's estate in bankruptcy, and the transferor's main purpose in making the transfer was to prevent the transferred property from becoming divisible among the creditors or to hinder or delay the process of making property available. Obviously, the key part of that is showing what your main purpose is in terms of defeating the creditors. Was your main purpose to defeat creditors? So the legislation itself says that the transferor's main purpose in making the transfer is taken to be to defeat creditors if it can reasonably be inferred from all the circumstances that at the time of the transferor was or was about to become insolvent. So if it's a factual scenario that it looks like we're about to become insolvent, it's going to be deemed to be a transfer to defeat creditors. That, however, does not limit the way that you can be deemed to be transferring to defeat creditors. So with that, in terms of some of the cases behind what our main purpose was it to defeat creditors? One of the cases that we often talk about is Cummins' case. which is a High Court case in relation to whether a transfer of a family home to his wife was to defeat creditors, I should say. So very shortly, the factual scenario behind that was we had a barrister, Mr. Cummins, who sometime before he became bankrupt, he transferred his interest in his home to his wife. So with Mr. Cummins, like most barristers, he wasn't very good at paying his tax, and he hadn't actually lodged his tax returns for 45 years of practice, which is a fairly good effort when you think about it. If you have a look at the date of the High Court decision, 2006, so what happened to Mr. Cummins was he got caught out by the introduction of GST, where all of a sudden, in terms of issuing his invoices, he had to include an amount for GST, so eventually the tax office caught up with him. So what the court found in that decision is they had a look at the facts, they had a look at the work that Mr. Cummins did, and in effect, they said, you should have known, considering your knowledge and your position as a barrister, you should have known that at some stage you would have to lodge tax returns. And when you did so, there was going to be a liability for tax. And with that, they said, because of that, your main purpose in transferring the property to your wife was to avoid the tax office and to avoid the tax office coming after you. So in that case, the court held that his actions were to prevent assets being divisible amongst creditors, principally being the tax office, and that was caught under that provision. Now, that doesn't mean we can't transfer our home to our wife for asset protection reasons, but in this scenario, it was clear that he knew that at some stage the tax office was going to catch up with him, so he wanted to move the home out of his name. Section 122 is preference payments. In terms of Bankruptcy Act, often we talk about preference payments in the Corporations Act, but there are similar provisions within the Bankruptcy Act as well. So with that, again, there is a table. We need to have a look at the time period for that as to when those preference payment period is. Otherwise, we'll be caught by Section 122. Coming back to superannuation contributions, again, main purpose in that has to be defeat the creditors. So it's not very widely litigated in terms of that. For the most part, it's recognised that superannuation is safe. Also, what's not really been widely litigated is Division 4A, which is in relation to entities controlled by the bankrupt. It has proven in that litigation to be very difficult for the trustee in bankruptcy to satisfy the use of this power. And there's only been a handful of decisions on the operation of this part, and principally for that reason. One of those decisions was Sheehan and Birdseye, which is a Western Australian decision. For a change here, one of the other cases I'll talk about later involves lawyers. For a change here, we've got an accountant. Always good to see accountants sharing the love in terms of them also having issues with bankruptcy rather than just the lawyers who don't lodge their tax returns. Accounting practice was conducted through a discretionary trust. The two main beneficiaries were Mr. and Mrs. Birdseye. Mr. Birdseye was the accountant. He received a salary of $15,000. And at the time, the analysis was that his market value salary should have been closer to around the $60,000 mark. So clearly, he's providing services to an undervalue in relation to the trust, considering he's only getting $15,000, and the rest of the money is getting lent to Mrs. Birdseye, who's then using it for living expenses and all the normal things such as paying a mortgage and so forth. So in the court, what the court went through was an analysis of the provisions and to see whether Division 4A applied. Was there a supply of personal services? That wasn't disputed. He was acting as an accountant for the trust. Acting as an accountant for a trust that was carrying on an accounting practice. Was it under the control of the bankrupt? Again, not disputed. It was within the examinable period, so it was within the time period that we need to examine in terms of Division 4A. Was there arm's length remuneration? No. Where the court differentiated for that is really whether the bankrupt benefited from the property. and in saying that, what they said was that the property is not the money that went to Mrs. Birdseye. It's in effect the debt owed to her, which in legal terms is called a chose in action. So then the question is, well, has the bankrupt, being Mr. Birdseye, benefited from the creation of that chose in action, being the loan to Mrs. Birdseye? He didn't use that in any way. So he didn't use that chose in action or the rights of chose in action. So he hasn't actually benefited from that loan in the strict legal sense. So in that decision, trustee and bankruptcy lost. So that shows the difficulty that they have in these sorts of scenarios in trying to use those provisions, and also shows really why there's only a handful of cases that have been litigated in terms of those provisions. Now, moving on to Corporations Act and focusing on the holding company liability for insolvent trading. And remembering that this has been changed somewhat by the COVID-19 changes, in that, in effect, there's a 6-month good harbour provision if it's for circumstances beyond our control due to COVID-19, so to speak. But what Section 588V does is that it can impose the liability in terms of insolvent transactions or issues in terms of our subsidiary company if we have a holding company and that holding company in effect is aware that our subsidiary company is trading whilst insolvent. So in terms of having a look at that, obviously we need to know what a holding company is, and that's defined fairly unhelpfully by saying that's where there is a subsidiary company. So then we need to have a look at what a definition of a subsidiary company is. And it says where the holding company controls the composition of the board and has more than half of the maximum number of votes at a general meeting, or holds more than half of the issued capital. So if we have a sort of classical two-tier scenario where we have a trading company with all the shares held by a holding company, and we've done that so we can bring profits down to the holding company away from the trading entity, then if our subsidiary company, our trading company, is trading whilst insolvent, that liability will sheet home to the holding company. So although good in the normal scheme of things, we still need to think about this sort of scenario and think about, well, is it actually better if it's held in a completely unrelated company? Because we don't want those liabilities coming back down to the holding company. So the liquidator of the subsidiary can recover from the holding company any loss or damage suffered by person to whom an unsecured debt is owed. The only defence that we have to it is that there are reasonable grounds to expect that the company was solvent. One of the cases in relation to this is Carrello and Perrine architecture, where we had one company that was wholly owned by another company that was an architecture firm. It had some issues and went into liquidation, and there was an insolvent trading claim against the directors and then also the holding company. Now, as usual in these sorts of circumstances, the holding company had the same directors as the subsidiary company. So they were held to be liable, and the holding company was held to be liable under Section 588V because in reality, because of those facts. Because we've got the common directors there, our knowledge of grounds to suspect insolvency has been shown. And there was a judgment of around $1.3 million against the holding company, which did have substantial assets because they'd been doing things like paying management fees and declaring dividends and all of those things down to the holding company. So something that we need to be aware of where we've got those two-tier structures that we still need to be careful about insolvent trading. So turning now to some of our solutions and having a look at them in the context of what we've just discussed in relation to both personal property and company-held property. And again, revisiting those provisions to see how they could apply and the sorts of things that we're going to need to think about in relation to them. So very briefly, in terms of our example here, we've got Ben and Penelope. They've got some joint assets in terms of a family home, personal assets in terms of a beach house, and a beneficiary account from an investment trust, with our total value of those assets or our equity being $4 million. So that's what's really at risk if either Ben or Penelope go into bankruptcy. Of course, we need to consider all of our solutions, and one of them would be what you would considered to be a traditional solution of transferring assets from risk over to a safe haven. But of course, we need to think about capital gains tax, stamp duty, land tax issues if we're transferring to a trust, for example. So needs to be considered, may not be the best outcome, but in some circumstances it can be, or those costs the client's willing to live with. One thing that we do need to be careful of, though, is that often there's a common misunderstanding that if we transfer the assets and we pay duty or we pay tax, then the clawback provisions don't apply. But they still do apply. So in the case of transferring assets away from individuals, we need to think about undervalued transactions, and we need to think about transfers to defeat creditors, as well as those preference payments provisions. So with that, just because we pay the tax doesn't solve our issue. And one of the questions we sometimes get from clients is, well, what if the trust or the company borrows and it pays me for the asset, so it's paid full value, so it's not an undervalued transaction? Well, that's true. The transfer of the property then would not be an undervalued transaction. However, the question then is, what happens to that cash? We've got, say, for example, we've borrowed $1 million to buy $1 million property. That cash is now in my hands. I'm not going to hold on to it. I'm going to give that away, or I'm going to move that somewhere else. And then we're back to square one, because that's our further undervalued transaction. So paying for it or not paying for it, we still need to think about those provisions. One of the things that we often do for clients in this circumstance is what we call the secured debt process. And it's all about what I discussed before, about getting the trustee in a position where it is a secured creditor. So somehow in our slides here, we've obviously got an error here. Ben and Penelope have changed to James and Karen. They must have changed their names as well as doing this work. But here we've got a gift of $4 million. The trustee company receives it. Now, there's no tax on a gift of money. So with that, there's no CGT, there's no stamp duty that's payable. So we make our gift of $4 million without there being any tax issues. Of course, in terms of Ben and Penelope, or James and Karen, depending on who you ask, that $4 million they don't have sitting in the bank, so we would document that using a bearer note. The trust then lends that amount back to the clients, and like any other lender, we'll want to take a mortgage over real property and a security interest over personal property. So that now our trust is elevated to a secured creditor. Of course, we still need to think about those clawback provisions, which we've outlined in terms of the Bankruptcy Act. So what if either of them were ultimately sent bankrupt? And the two main things that we would need to consider in that circumstance are undervalued transactions, Section 120, and transfers to defeat creditors. So with the undervalued transactions, as I said earlier, we have a 4-year period. If they're insolvent, then it's 5 years. So obviously, if we're doing any sort of this sort of work, we would recommend that a solvency statement be obtained at the time of the gift. But once we're outside that 4-year period, then we're outside that provision. There's no clawback. So that does put us in a very strong position. I know 4 years sounds like a long time. However, believe it or not, it does go quickly. And we need to remember, that's why we stress the fact that we need to focus on those dates in terms of the relation back date. It's that date that's important for the 4 years. It's not the date that we get served with a claim. It's not the date that we go to court. It can be a date much later. So if our numbers are big enough in terms of what we're trying to protect, it may be worthwhile delaying things if we do get served with a claim, so we can get outside that 4-year period if we've done this work. Of course, that doesn't apply to transfers to defeat creditors. So if we're already getting sued, or our clients are already getting sued, no, we can't do any work at that time in terms of protecting against that claim and not get caught by a transfer to defeat creditors. Because that's motivation a factor, not time, and there is no time limit for transfers to defeat creditors. Remembering our two main parts in order for it to apply is that our main purpose is to defeat creditors, and the property would have been available. So coming back to that main purpose, which we've discussed in Cummins' case, the case involving the barrister who hadn't lodged his tax returns in 45 years, we still need to have a look at our factual scenario. So clearly, it's going to apply to existing creditors, because it's very difficult to say that anything that we've done wouldn't impact on those existing creditors. But the scenario is different for future creditors or contingent creditors. In terms of Cummins' case, we've discussed that. That transfer was 15 years earlier. There is another case, Florence's case, which also talks about the main purpose. So in doing that, we need to produce our evidence to show our other purpose, and they might be commercial reasons, they may be tax reasons, they may also be family and domestic case. Now, remembering that Mr. Cummins, the barrister, tried to say he transferred to his wife for family reasons, clearly in that case, as the tax office were found to be creditors of Mr. Cummins. The difference with that and the case of Florence's case, in that scenario, again, we've got a lawyer. He transfers his property, his interest in his main residence, to his wife. But he was able to produce evidence of his wife, in effect saying, unless you transfer that property to me, considering you're a lawyer and you may get sued, we're over. It's Splitsville. We don't need to be worried about being self-isolated together in the days of COVID-19. We're over now unless you transfer that property to me. So being able to produce that evidence showed that the main purpose wasn't to defeat any creditors. The main purpose was really that domestic reason and to keep his family situation happy. So that's one of the cases that we can refer to, and we can have a look at the sorts of evidence that we need to produce to show what our main purpose was. So what about company assets? And we haven't gone into some of the other provisions in the Corporations Act, which we'll touch on in relation to that. The sort of things that we'd want to protect in the company is clearly going to be goodwill or long-term capital assets. So, for example, if you have clients in the drilling industry, the drill rigs themselves, they maintain their value for a long time because it's just the drill bits that wear out. And that's really what we're using to generate our business if we're in the drilling industry. So we may have a lot of long-term capital assets, or we might have retained profits and cash reserves, and we need to have a look at ways of protecting those. So Paul did cover them in our presentation last week in relation to protecting company assets. So I won't go into them in detail, but obviously the idea would be, to the extent possible, we would establish a reserve company with all of the shares held by a trust. And then we would declare, if we were dealing with retained profits, we would declare dividends out. Whether we do that by changing shares or issuing dividend shares, there's a few different ways to do that. If we're dealing with goodwill or the value of goodwill or the value of large capital assets, we could look at gifting that value over to the company. And then the idea being that that reserve company either lends a dividend back to the extent that we need working capital, or lends the gift back in terms of that goodwill figure or that those capital assets. Again, the idea being that we're putting our reserve company into a position where it's a secured creditor of our trading entity. So with that, the sorts of things that we need to consider, and we're not going to cover any of the tax issues in this presentation. Paul covered them last week, but we are going to recap on the validity of the gift under the Corporations Act, and then also those statutory clawback provisions under the Corporations Act. Because we need to have a look at, there's no point doing any of this work unless we're confident that we're not going to fall afoul of any of those clawback provisions. So, can a company make a gift? It sounds a bit strange. Short answer is yes, it can. It's legally able to make a gift due to Section 124 of the Corporations Act. Of course, we do need to remember our directors' duty to shareholders. Very often in this scenario, it's going to be a closely held business, but it's still a best practice and certainly something that we do, that we get the consent of the shareholders to the gift, because we're giving value away from our trading entity if we're making the gift. In terms of the clawback provisions, the main ones in the Corporations Act are what you'd call avoidable transactions, and they can either be insolvent transactions or not insolvent transactions. What I mean by that is classified as insolvent transactions under Section 588 FC are unfair preference payments, uncommercial transactions, transactions to defeat or defraud creditors. And then separately, we have Section 588 FDA, which is unreasonable director-related transactions. The main things with these is to have a look at what the time periods are, because then we can ascertain what, if anything, that we've done is protected or is at risk of being clawed back. So unfair preference payments, it's a 6-month clawback period. Uncommercial transactions, 4 years. And transactions of defeat or defraud creditors has a 10-year clawback. So if we have entered into any of these transactions, whether it's a preference payment or uncommercial transaction, we need to be aware of that time period. Because like with most things, if we're in this world where our client has hit a hurdle and we're looking at what can and can't be saved, we're going to have to be realistic and work out exactly what is at risk and what can be saved in relation to that. And having a look at these provisions and the time periods is a big part of that. The other one that I mentioned is Section 588 FDA, which is unreasonable director-related transactions. So this was introduced following the collapse of OneTel, for those that remember that debacle. And the reason that it was introduced was shortly before the collapse. The directors of OneTel decided to pay themselves a very large bonus. Obviously, they thought things were going well, so they decided to reward themselves for their efforts. So to counter that sort of scenario, this provision was brought in, so unreasonable director-related transactions, which has a 4-year clawback. And that's where we have any transaction with another company owned by a trust or controlled by directors. And it applies whether we're not insolvent. So in terms of the insolvent transactions, we have to be insolvent at the time of those transactions. However, 588 FDA doesn't have that provision. It can apply at any time. So just coming back to this diagram, if we're making a dividend, we're declaring a dividend, not so much an issue, but certainly if we're making a gift, that you would think that would be caught by the unreasonable director related transactions. We often have a debate within the office whether it's caught or not, just due to the wording of the actual provision. However, it's safe to assume, or it's best practice, you could say, to say to clients that that's very likely to be caught. So again, we have in effect a 4-year period under that provision. So the idea being that if we've done anything like that work within that 4-year period and our company goes into administration or goes into liquidation, then that could be clawed back. So again, as usual with this sort of work, often we say to clients, the sooner the better. We get that clock ticking, whether it's individual issues and Bankruptcy Act, that 4-year period, or whether it's Corporations Act, again, getting this 4-year period ticking as well. In terms of liquidators and their attitudes currently, still finding them quite aggressive in matters. Clearly, they probably were doing handstands and cartwheels when some of the shutdowns started in terms of COVID-19 and licking their lips and rubbing their hands together. However, I would think that some of the provisions that have been brought in terms of delaying those 6-month period would continue to reduce their workload. So I expect them to continue to be aggressive in these sorts of matters moving forward. Recapping, we talk a lot about wanting to be a secured creditor, and the reason for that is that the rights of the secured creditors have priority over unsecured creditors. We've seen that in the Bankruptcy Act. It's also contained in the Corporations Act. They have the right to deal with the secured assets directly, and really any creditor has priority over an owner. As an owner, you don't have any priority in terms of that. So it's not good enough to be an owner. We also want to be a creditor of ourselves, of course, in a different capacity, so that we can control things. Because at the end of the day, these things are about control. If we can exercise that control, or we can make it difficult, that puts us in a good bargaining position with anybody that we're having to bargain with or have a dispute with. Okay, I'm going to throw it open for questions there. And unless some questions come through, I'm just going to turn my mic off and let Paul do a little bit of housekeeping.
For whatever reason, Adrian, I can't see myself on. Hold on, that's right. There we go. Adrian, I might just jump in. Although Mark asked his question earlier, he unfortunately had to leave, but I thought I did a little bit of looking while you were speaking. essentially the protection that directors receive in relation to, I guess, the changes to insolvent trading, they do only relate to essentially debts that have arisen during the COVID period. So if you were insolvent trading, prior to COVID, well, you don't get any protection for that. But obviously, if there is a debt that's incurred that causes you to trade whilst insolvent during this COVID period, you will get that protection. So I hope that clears that up for Mark, but we'll obviously send him an email separately. I don't have any more questions coming through on the chat. If anyone wants to, well, here we go. A question from Brett. If the trust that receives the gift takes security on the property, what is the situation if a bank already has a first mortgage?